been formally accused and bound over to state court. Defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney at this proceeding. All participants, this particular proceeding is being broadcast over the internet as a live stream. It is also being recorded. That means that any member of the public can log on and watch this. Those who receive a surety or cash bond today will be reset to the SAP calendar. Ms. Bridgewater, what is my SAP reset date?
It's December the 6th.
All right, it will be so reset to December the 6th. Those who receive a signature bond, whether through the jail or pretrial, will be reset for the notice. Is the defense or the state requesting any breakouts as it pertains to any positions today?
Good afternoon, Your Honor. Yes, for breakout for position number 1.
All right, thank you.
Yes, Your Honor. I would like to have a breakout for position number, I don't have a position number, Harmon Candice, Your Honor.
All right, we'll do those breakouts at the end.
Thank you, Your Honor.
All right.
That's position number 10.
10. Yes, Your Honor.
All right, so 1 and 10. All right, who do we have first?
Good afternoon, Your Honor.
Good afternoon.
We have position number 4 here at South Annex.
All right. Good afternoon. Are you Ms. Caldwell?
Yes, ma'am.
All right, Ms. Caldwell, your case number is 22CR007932Y. In that case, you're charged with battery family violence with the offense date of November the 22nd. Do you understand your rights here today?
Yes, ma'am.
All right, Mr. Howard, can I have her history, please?
Fourth arrest, 2018 battery, DV. He was dismissed out of Florida. 2013 possession of meth with intent, misdemeanor possession of marijuana.
Okay.
Said record restricted, well, they were there, docket. 2017 DUI conviction. That's it.
Okay, thank you. Ms. Campbell, I believe this is your case, is it?
Yes, Your Honor, that is correct.
All right, will you please proceed?
Yes, Your Honor. The facts as alleged for this defendant are that on the date of November 22nd of this year, which is yesterday at the location of 5410 Mount Vernon Parkway, officers received a call for a domestic dispute. Upon arrival, they were met with the victim in this matter, Mr. James Caldwell. He did advise the officers that his daughter, the defendant, was highly intoxicated. She had been drinking all night and she was not taking care of her child. He stated that she fell from being drunk and she created a minor scratch on her child. At that time, the victim did take his grandchild into the bathroom to bandage her, and this defendant did proceed to follow him in the bathroom and bite him on both of his legs. And so when the officers did arrive, they did also observe that she was highly intoxicated and visibly drunk. As pretrial mentioned, she doesn't have any prior violent convictions. And we have had contact with the victim. He states that they live together and that this is out of character for this defendant. However, the state does still believe that this defendant poses a danger to the victim based on the seriousness of the allegations in this particular matter. She bit her dad in both legs while she was drunk and her minor child was present at the location. So for that reason, the state is recommending a $3,500 surety bond. No contact with the victim, Mr. James Caldwell. Now, I will note that the victim did ask for no violent contact, so I will leave that to the court's discretion. I'm also recommending that this defendant have an alcohol evaluation and treatment, as it looks like these events were precipitated by her being drunk and intoxicated. Nothing further from this.
And I'm assuming you're also requesting to stay away as well, Ms. Caldwell, from that address on Mount Vernon, since you said they live together.
That is correct, Your Honor.
All right, thank you. Who represents Ms. Caldwell?
Your Honor, Kevin Ryan for Ms. Caldwell.
All right, good afternoon, Mr. Ryan. Please proceed.
Your Honor, I have the alleged victim here, her father. I have no problem with anything. We're just asking a no violent contact order. She lives with her father as well as her young child, and he is here. The state did represent that it's his desire to have a no violent contact. that would be the only condition I'd ask the court to consider, a no violent contact order, because they do live together and it's also her child. Other than that, I'm okay with the bond amount and the evaluation and treatment if required.
I'd like to speak with Mr. Caldwell, if that's all right. Is that Mr. Caldwell there behind you?
Yes, ma'am,
Mr.
Your Honor. Yes,
Mr. Caldwell, will you please raise your right hand?
yes,
Do you swear and affirm the testimony you give to this court today will be the truth to the best of your knowledge and under the penalty of perjury?
yes, ma'am.
All right, you can put your hand down. What the court just wants to make sure and make clear is that you wish to have contact with this defendant?
Yes, I do. I think that was very out of character, and I don't believe that will ever happen again. My daughter, and I love her very much, and her daughter, her daughter is at my house now, and she loves her daughter very much. I think this was just an odd and strange incident, and I don't
All right,
will ever happen.
all right. Thank you, Mr. Caldwell. And Mr. Ryan, the defense is not objection to the alcohol evaluation at this time either?
No, Your Honor, we don't have any problem with anything the state's requiring on that end, just ask that there's no violent contact.
All right. We will accept the state's recommendation with the exception of the contact. It'll be a no violent contact. But Mr. Caldwell, she will complete that ADET and she will receive a $3,500 surety bond. Is there anything further from either party?
Your Honor, just a procedural question. Go down and post the bond in Union City or go to Rice Street and post the bond?
I believe it's Union City. Is that correct, Mr. Howard?
Okay.
Do you know? I don't know. I honestly don't know, but I
What's
believe
your
it's where
question,
she
Judge?
is. Do you know where we go to get her, where they can go post the bond? Is she in Union City?
Who
I
in
guess
Union City?
so. Position 4.
She would be brought back to the main jail before she released.
Oh, okay. So that should answer your question, Mr. Ryan. She'll
Yes,
go to
sir.
the main jail.
Go to the main jail, go to Rice Street. Yes, ma'am.
I have a
Okay.
question as well.
Is this
Do
a
we
good?
take away the stay away?
No, there's no stay away. I did no further, no violent contact.
Okay,
This
no
is a
stay
good
away.
bond or a signature bond?
It's a good bond.
Okay. But they can go to
Alright.
bonding company and bond her out.
Yes, either that
That's
or go.
true. That's true as well.
But
That's
she
true.
will
Okay.
go back to the main jail before she's released. Because they
That-
process
That
it.
was really the question. Where do you go
Yes.
to get her? Okay.
Not where you go to get her, where you go to post it.
Where you go to post it? That's what I meant.
At a bonding
All right.
company.
No, we may not use the bonding company, so if he goes to post them all the cash.
Oh, if he posts cash, he would go to the main jail, Rice Street,
Yes, sir.
901.
Yes, thank you.
All
Will we
right.
be-
I believe
be
that
excused,
concludes
Your
all
Honor?
business. Yes, take care. Have a great afternoon.
Thank you, Judge. Happy Thanksgiving.
All right. Happy Thanksgiving to you as well. All right. Who do we have next?
Position 2, Mr. Blassingame.
All right. Good afternoon, Mr. Blassingame. Your case number is 22 CR 007935A, in which you're charged with 1 count of disorderly conduct and 1 count of simple assault with the offense date of November the 16th. Do you understand your rights?
Yes,
You say, do you understand your rights?
yes, yes.
All right. All right, Mr. Howard.
A blasting game. Last arrest was 2019. Failure to disclose information. He was out of Ohio. That was dismissed. 2013 arrest in Georgia. Shoplifting. He went to felony earlier. I was told he got a $6,000 good bond.
Okay. All right, thank you. Ms. Campbell.
Yes, Your Honor. The facts as alleged for this defendant are that on the date of November 16th at approximately 10:30 a.m. at the location of 130 Peachtree Street in Atlanta, this defendant stood up and he invaded the personal space of 3 different victims. Their names are Chris Barrieres, Alicia Davis, and Nakori Wright. He invaded their personal space, and this is a government building, and he began yelling profanities at them and threatening to cause them bodily harm. He basically told them, "I will F y'all up." And these are all employees of the Fulton County Registration and Elections Department. And so the state does believe that they were all working within their official capacity at the time of this incident. And so we have had contact with the victim in this matter, and they let us know that this defendant was a poll worker on the date of the alleged incident, and that he came there to collect his paycheck. And Miss Davis, our primary victim and witness, stated that she let the defendant know that the check was not there yet, but she assured him that he would get it soon. At that time, he began cussing at her. The other two employees that I mentioned, they proceeded to come to see what the commotion was about, and he began cussing and threatening them as well. He did have to be escorted off the premises by police officers. And the reason why he has an open case in Superior Court is because he did return to the location approximately 6 days after this incident yesterday and began threatening the people in the government building again. This time he threatened the security guard, which gave rise to a felony charge for terroristic threats, which is, as pretrial mentioned, he has a $6,000 good bond for that case. The state does believe that this defendant poses a danger to our community. More specifically, we have received several calls from citizens already about this specific defendant. They have stated that he harasses people within the community consistently, and that for those reasons, the state does believe that he's a threat to the safety of the community as a whole. And so, in light of the fact that we've received several calls about this defendant, about him harassing people in our community, and the very serious allegations before the court today with him threatening government poll workers, the state is going to be requesting a $6,000 surety bond, $3,000 on each count. So $3,000 on the assault, the simple assault, and $3,000 on the disorderly conduct to account for all three victims of the disorderly conduct to which the defendant threatened 3 people. And so I would also like to note, for your honor, that he has been flagged as a combative inmate in the jail. So that is consistent with him being a threat to others in our community. And so that is the state's recommendation at this time for bond, nothing further.
All right, thank you so much, Ms. Campbell. Ms. Gant, please proceed.
Thank you, Your Honor. Mr. Derek Blassingame is 36 years old. He relocated to the Atlanta, Georgia area in 2010 to began attending college at Clark Atlanta University. He has family here, has several cousins, Your Honor. Mr. Blassingame completed high school, and he is currently enrolled as a student in his senior year, studying business administration at Georgia State. He has a GPA of 2.4. This is the week for final exams, Your Honor. His final exams are scheduled next week. He is on track to graduate in spring of 2023. He does not have the means to pay anything toward bond to be released. He only works part-time at a Sensa Health as a residential advisor. Mr. Blassingame expressed to me that the charge back in 2018, the charge which was subsequently dismissed in 2019 arose from him not having his driver's license to present to the officers. It wasn't a refusal. He states that his driver's license was actually on the seat. He had been sleeping in his car because he was homeless. He has also expressed that he had been homeless for periods of time since 2020, largely due to the pandemic. He lost his income. He had to, again, just sleep wherever he could. He was finally able to get back on his feet in June of 2022. He is a productive citizen. He strongly denies the allegations, Your Honor. He states that on the 16th of November, he was, as the state stated, there to work as a poll worker. He stated that when he came to that facility, he was invited to pay he was invited to that facility by Mr. Barrios to pick up his paycheck. He states that when he arrived, the security officer began antagonizing him. That person was armed and he frankly felt threatened. He states that they were actually cursing at him. He states that he also went to the Board of Commissioners to complain how poorly he was treated. Now, in terms of the state's contentions that there are unnamed witnesses, Your Honor, my client is entitled to due process. He has the absolute right to confront his accusers. I would ask that you not consider any complaints from any unnamed witnesses. My client is deemed combative, a combative inmate. That is purely subjective. You can see that he is sitting here calmly now. I was able to interview him without any resets whatsoever. So we disagree with the state's contention that he's combative. Yes, he's upset because of these false allegations, which he intends to defend. And lastly, Your Honor, my client is not a danger to the community. We heard his arrest history. I did not hear about any convictions whatsoever. I heard about a dismissal in 2019. We explained to the court what happened there. We heard about a shoplifting charge in 2013. There is no disposition. Your Honor, I'm requesting a signature bond on Mr. Blassingame's behalf. We need to actually consider him what he actually is, presumed innocent of this case, as well as any other open cases. And Your Honor, grant Mr. Blassingame a signature bond to return him to school so that he may complete his education, take his final exams, Your Honor. Thank you. And we are actually, there isn't a request for any stayaways. I don't recall hearing a request for a stay away, but that is a government building, Your Honor, and I would ask that he be allowed to return there if he is on official business. Thank you, Your Honor.
All right, at this time, the defendant will receive a $2,000 surety bond, 500 count one, 1,500 count two. He is to only return to that location if he has official business and have no alcohol, drugs, or weapons as a condition. Is there anything further?
No,
Nothing
Your Honor.
further from defense. Thank you, Your Honor.
All right, best of luck to you, Mr. Blassingame. Who do we have next?
Position 10, Ms. Harmon.
Can we do that position last? We're gonna do all the breakouts at once.
Okay.
Thank you.
Position 3, Mr. Barnes.
Okay, Mr. Barnes, your case number is 22 CR 007933E. In this case, you're charged with battery family violence. Do you understand your rights? Is that a yes? Do you understand your rights today? All right, thank you. Mr. Howard?
I got history out of Maryland and Virginia. Last arrest was back in September for battery DV. It's 22 CR 006307E. Got a simple battery family violence, 22 CR 002291E. 2020 assault second degree out of Maryland. That was non-pros. Another 2019 assault second degree. 2012 possession of marijuana, and a 2018 larceny conviction out of Virginia. I think that's it. Yeah. So he got the two open cases.
Okay, thank you. And I'm sorry, the last open, the battery DV was what year? 2019?
The battery DV, the last one was back in September this year.
Oh,
He got
September this year.
22 cases that are open.
Okay, thank you. All right, Ms. Campbell, please proceed.
Yes, Your Honor. Pretrial is correct. This defendant does have two open cases here in state court for battery family violence. Actually, one of them is a simple battery family violence. The incident date of that one was April the 17th of 2022. So a little over 7 months ago. He does have a $5,000 good bond on that case, and it is the same exact victim in this case, Miss Dream Jackson. And he was instructed to have no contact with Miss Dream Jackson whatsoever in that bond order. Additionally, as pretrial mentioned, there's also an open case from September 18th of 2022 with the same victim, Miss Dream Jackson. He has a $2,500 good bond in that case. And again, he was instructed to have no further contact with the same victim, in this case, Miss Dream Jackson. So what we have here is, Your Honor, who is somebody who is already on bond for physically and violently attacking his girlfriend, Dream Jackson, and is completely non-compliant with the court orders to stay away from her. Not only is he not staying away from her, but as alleged in this particular incident, Your Honor, he has beaten her again. And more specifically, the allegations are that on November the 3rd, at the location of 1991 Delow Drive, which is also the same location that he was instructed to stay away from in those 2 prior orders before this court here. This defendant punched the victim, Dream Jackson, in her face with a closed fist. He also bit her on her finger. And when the officers arrived, they did observe that Dream Jackson had a busted lip, and she did have a bite mark, a visible bite mark on her finger. And the parties do live together, and they've been in a relationship for 2 years. So within 2 years, we have at least 3 documented incidents of this defendant beating her up. And so, Your Honor, the state is looking into adding, potentially transferring this case for aggravated stalking charges to the DA's office, because this is a reoccurring, this is something that's reoccurring. Additionally, Your Honor, we have filed motions to revoke his bond in those 2 open cases. And we have had contact with the victim. She does state that she was aware that he was ordered to have no contact with her. She also states that she's since moved from the residence, and that as recently as a few days ago, she filed a temporary protective order against this defendant, and it was granted and it was served on this defendant. It's my understanding that she's going to be present on the Zoom call today. So in light of all that information, Your Honor, the state's recommendation for bond is going to be a $10,000 cash bond, anger awareness, no further contact with Miss Dream Jackson, as well as a stay away from the incident location of 1991 Delow Drive. And obviously this will be the instruction of the court for the 3rd time in 7 months. But that is the state's recommendation at this time, nothing further.
All right, thank you. I'm gonna sound for Ms. Jackson first. Ms. Jackson, if you're present on the Zoom conference and wish to be heard, I need you to turn on your camera. Okay, Ms. Jackson, would you like to make a statement?
Yes.
Okay, before you begin, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge under the penalty of perjury?
Yes.
All right, you can put your hand down. What the court is most concerned with today is whether you wish to have contact with the defendant. What would you like to tell me at this time?
So yes, I would like to have contact, and also at the September incident, I specifically explicitly told the judge that we moved into this state as the only 2 people that we know, so that putting us in a situation where we would have a no contact order would not be the best option, because that means one of us would either have to live on the street. That's the only option, because we don't have anywhere else to go. And I explicitly over and over again let her know that. Also, the TPO was served a week and a half ago, and when I spoke to the detective on Monday, he deceived me in letting me know that he would be putting out an arrest warrant, because I did let him know that the TPO process was completely done, completely over with. I've already been granted the TPO with no hesitation, no issues. And I haven't had any further issues or confrontations with Mr. Bourne since that TPO, which was like the 7th of November. So I would not have even pushed forward to have this arrest warrant issued if I had known that was the case, because I've already settled it with the TPO order and it's already been taken care of. In the past 7 months, me and Mr. Bourne have been in a continuous relationship since each one of these situations, which I'm pretty sure that we have let the judge know and the court know every single time that we are continuously in this relationship. So a no contact order doesn't really fit the situation that we're in. Also, I know a stay away order does not fit said situation as well, because we live in the same house. And since we are not able to leave the state due to all these other situations that we have going on, we also don't have nowhere to go. Therefore, one of us would have been on the street. Once I was able to get said TPO 30-day situation, the victim services did not assist me in getting a housing situation, nor did they assist me in any type of resources that would involve me having a safe place to stay while I was going through that process. Therefore, that's not like the services that were provided did not assist me. Therefore, I don't need them. So I would prefer if, one, he wouldn't have been arrested in the first place, but 2, if he could get out on bond, because since he's been arrested in the past 3 months, them 2 times, we don't have no money to get him out of jail again for something that he really shouldn't have been in jail for that was taken care of with the TPO. Thank you, Your
Okay.
Honor.
All right, thank you. Ms. McLeod, please proceed.
Yes. Yes, Your Honor. I know this situation may sound a little complicated and that he's been arrested 3 times. I represented him when he was arrested in September. He is 30 years old. The parties have been in a relationship for the past 3 years. They moved together to the state of Georgia. As Ms. Jackson has stated, they don't have anyone else here in Atlanta. So they rely on each other. However, since the second arrest, even though it was extremely inconvenient, one of them had to be sleeping on the street. Miss Jackson told me that at one point she had to go sleep in her car at one point. So they agreed that much as it would be a hardship, that she would move, and that she has moved. And he is living in the property by himself as of now. But it was the reason why they had to have contact, and she told me, and he told me the same thing, was just in terms of moving out and getting all of that situated so that she could get her stuff and so on. And she told me, and she was pretty upset about this and quite adamant that the detective was very deceptive, because she told him point blank that she was fine and she did not want to pursue any charges against my client. Your Honor, if he's given a $10,000 cash bond, that is essentially no bond for him. He doesn't have anyone here, and he's in no position to find $10,000, $5,000, $1,000. He's just not in a position to do that. The last time he received a bond, he was bonded out from his mom, who is not available to bond him out. So essentially, he's just going to be sitting in jail. As the alleged victim has stated, she's okay. She has new accommodation. She has moved. This is what she told me, because I spoke to her before we came on the Zoom. I would definitely understand that they have a volatile relationship, but what I am hearing now is that they are no longer in a relationship. So going forward, they are not going to be having this issue. I would ask the court to take that into consideration in setting his bond, because he's just not in a position to pay a cash bond and he has no one to help him do so. Thank
Ms.
you.
McLeod, I understand what you're saying, but that doesn't seem to be what the witness said. It seems as if they're going to continue to live together. You're saying that he has somewhere else to go at this point?
My understanding was that he was going to be staying at the Delow Drive address, but also if he told me that she has moved, and that was the impression I got from her, that she has moved from that location now, just recently.
Okay, all right. Anything further from either the state or the defense at this point?
Yes, very briefly, Your Honor.
Very briefly, yes, ma'am. Very briefly.
Okay, just briefly want to say that I think the fact that the victim went and got a TPO a few days ago, I think that speaks volumes as to, you know, her present state of mind as it pertains to the defendant. I mean, nobody goes to get a TPO unless they're afraid of somebody trying to hurt them. Nothing further.
All right, at this time, the defendant will receive a $3,000 cash bond. He's to have no contact with the alleged victim in this case and stay away from the address on Delow Drive, have no alcohol, drugs, or weapons. If the alleged victim is not at the Delow Drive location, he can return to that location. He can return one time with a member of law enforcement to make that determination. Is there anything further from either the state or the defense?
No, Your Honor, thank you.
All right, best of luck to you, Mr. Bourne. Who do we have next?
Position 5, Mr. Caldwell.
All right, good afternoon, Mr. Caldwell. Your case number is 22 CR 007938E, in which you're charged with giving false information with the offense dated November the 22nd. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard.
20 total. Last arrest was 2021, fleeing an officer. On probation and card, possession of a Schedule 1 or 2 controlled substance with intent, possession of a firearm by a convicted felon or felony first offender, unlawful for a person to participate in criminal street gang activity. 2017, they gave him 2 years to serve, 12 years probation. Nice. Charges dismissed. I got probation violations from 2016. What else? Possession with intent, suspended license, another suspended license, another probation violation. Underlying charges, battery DV, that's from 2013. You
Okay,
got first offender in 2010 for theft by receiving gun. Hold on,
that's
shit.
good. That's good. That's good. I think we're in 2010, so I think anything beyond that might be too remote. All right, Ms. Campbell, please proceed.
Yes, Your Honor. The facts as alleged for this defendant are that officers were dispatched for a call for a person stealing a vehicle. Upon arrival, they did observe this defendant and a co-defendant who's facing charges in Superior Court standing near an abandoned vehicle. And the officer observed that the abandoned vehicle had a busted out window and parts to a vehicle inside of the car as well. The officer also observed there were other people located at the scene of this incident and 2 other vehicles. It's important to note that inside of one of those other vehicles that was near where the defendant was at, there was a stolen handgun, live rounds, as well as a distribution amount of marijuana and a pill of ecstasy. The officer did ask this defendant and his co-defendant for their names, and the defendant did give a false name to this officer of David Montgomery, which is clearly not his name. So that's what gives rise to the charge before this court today. Your Honor, the state does have serious concerns about this defendant being a danger to the community and a risk of reoffending. Now, that's in light of the fact that, as pretrial just mentioned, this defendant is on probation for criminal street gang activity and theft by receiving stolen property. There was also possession of firearm by a convicted felon. That was actually a 21 count indictment out of Cobb County. And so the charges in that case, the state believes they are analogous to the facts in this case, where this defendant is again at a location with other people, arguably other people he's in a gang with. We don't know. He's there. They have car parts in a abandoned vehicle. They have other vehicles on the scene. And one of those vehicles had a stolen handgun and live rounds. Not to mention, in that particular vehicle, Your Honor, there was a receipt with the defendant's name on it, Mr. Caldwell. And so the state is doing further investigation into this case. We're looking into having this case upgraded to a felony because of all that has happened. And the state does believe that with the prior convictions, the prior probation, all involving theft. You heard pretrial say theft by receiving an auto, financial transaction card theft, felony theft by taking, forgery. And here we have him again doing similar things. The state believes he's a risk of reoffending and that with that handgun, he is a danger to everybody in this community. So for those reasons, the state's recommendation is a $7,000 surety bond. And the state is also recommending that, stay away. We're just recommending the $7,000 surety bond because the state does believe that that's appropriate in this case in light of the fact that we are looking into upgrading this to a felony for potential gang activity.
All right, thank you. Mr. Lynch, please proceed.
Yes, Your Honor. My client is 31 years old. He has spent his entire life in Atlanta. He does have his own business. He does a tow truck company. He has a tow truck that he operates. He has several minor children that he supports. And, you know, we'd ask that in setting bond in this case, you primarily consider the charge that is before you, which is 1 count of giving false information. I understand the state is looking into upgrading the charges, but today he's here for giving false information. He's entitled to a reasonable bond on that charge. And I would ask that you set that bond in an amount that he can make so that he can get back to doing his work and providing for his family. So I would request that, Your Honor, if you're not to set a signature bond in this case, that you set the bond at no more than $1,000, an amount that he can make. You know, I don't believe there were any recent violations of probation. I think the last one that was mentioned was from 2016. And so, you know, Your Honor, I believe that my client will appear before the court and resolve this matter. Whether the state intends to upgrade the charge or to add additional charges is not what's before the court today. Today, we're asking for a reasonable bond based on the offense alleged before the court, which is one count of giving false information.
All right, at this time, the defendant will receive a $2,000 surety bond. There was no stay away requested, and he is to have no alcohol, drugs, or weapons. Is there anything further?
No, Your Honor.
No,
All
Your
right, best of luck to you, sir. Does that complete your business, Mr. Lynch?
It does, Your Honor. Thank you very much. May I be
All right. Yes, take care. Have a great Thanksgiving. Bye-bye. All right, who do we have next?
Position 1, Mr. Bean.
All right, good afternoon, sir. Oh, this was a case the state also requested a breakout. So can we take that at the end as well? I mean, the defense requested a breakout. So
Yes.
can we go to a different position, do all the breakouts at once?
Position 6, Mr. Choritos.
All right, sir, good afternoon. Your case number is 22 CR 007930G. You're charged with a willful obstruction with the offense date of May the 24th. Do you understand you're right?
Yes, Your Honor.
All right, Mr. Howard, can I have that history?
Got 11 total. Last arrest was back in May. Failed to appear, two counts of ag stalking, 1 count violation of family violence order. He's on probation for ag stalking. They gave him 5 years probation for that. In Cherokee County, that was last week, looks like it. 2020, failed to appear, battery DV, false imprisonment. The false imprisonment was dismissed. The battery DV was transferred to state court out of Woodstock. 2020 battery DV, felony terroristic threats arrest. Suspended license NOLO from 2019. 2019 probation. Misdemeanor possession of marijuana, possession of alcohol below legal age. That was a conviction from 2019. 2018 disorderly conduct conviction. 2018 cruelty in the third and battery. The battery was amended to disorderly conduct. I got possession of drug-related objects that was dismissed from 2018. And the 2016 trespass dismissed.
All right, thank you. Ms. Campbell?
Yes, Your Honor. As pretrial mentioned, this defendant does have a very lengthy history dating back to 2016. It looks like he's been picking up charges and cases ever since then, every year. Most concerning to the state is that first offender probation that he's currently on for aggravated stalking and harassing phone calls. And the allegations in this particular incident, they actually relate to those charges out of Cherokee County for which he's on probation for. It's alleged that on May 24, 2022, in Roswell, near the location of Norcross Street and Alpharetta Street, the Cherokee County Police Department or Woodstock contacted the Roswell PD to get assistance with apprehending this defendant because he was wanted out of Cherokee for those aggravated stalking charges. They learned that he actually was a manager at a business in Roswell, so they did go to the location and they did find the defendant located there. The officers did issue him verbal commands to stop when they saw him. In response to this directive, he ran away from the police officers and he jumped over a retainer wall and he went into a locked parking lot. The officers had to actually have the owner of the parking lot let them into the parking lot. And when they did get inside, they did find the defendant hiding underneath a parked car. They gave him commands to come out. He was not compliant initially, and eventually, after giving him several commands, he did come out. And so the state is concerned about this defendant being a flight risk. I don't know if pretrial mentioned, but that on that 2020 battery family violence case, he FTA'd twice in Cherokee County. And here we have him running away from the police. And here we have him just, again, fleeing. So he is a risk of flight and a risk of not showing up for court. And so for those reasons, the state's recommendation is going to be a $4,000 surety bond and no alcohol, drugs, or weapons while on bond.
All right, thank you, Ms. Gant.
Thank you, Your Honor. Mr. Nicholas Chiritos is 24 years old. He has been in the Atlanta, Georgia area since age 13. He has a 7-year-old daughter. He also has his mother here, therefore he has community ties, Your Honor. Mr. Chiritos completed the 11th grade. He was employed at a local bar and grill. He had been in that position for 1 year, Your Honor. When Mr. Chiritos was arrested back in May, he has not been released from jail. Therefore, he does not have the means to pay anything toward bond, Your Honor. He doesn't have any family resources. These are allegations, Your Honor. My client is presumed innocent. He, certainly is deathly afraid of the police. I would ask the court for a signature bond, just given the date of this, the date of the offense. And I do acknowledge my client's history, but there are no allegations of any violence here, Your Honor. So in closing, we're requesting a signature bond on Mr. Chiritos' behalf. And we do not believe that he is a flight risk, Your Honor. There just isn't a basis for that. Thank you.
All right, at this time, the defendant will receive a $1,000 surety bond, and he is to have no alcohol, drugs, or weapons. Is there anything further?
Nothing from the defense. Thank you, Your Honor.
No, Your Honor.
All right. All right, best of luck to you, sir. Who do we have next?
Position 9, Mr. Hampton.
All right, good afternoon. Your case number is 22 CR 007936C. In this case, you're charged with stalking with the offense date of August 25th. Do you understand your rights today? You have a right to remain silent. You have a right to an attorney. Anything you say can and will be used against you. You understand that?
Yes.
All right. Mr. Howard.
First arrest.
All right, thank you. All right, Ms. Todd, will you please proceed?
Yes, Your Honor, thank you. This is the case of stalking, Your Honor, between the defendant and a Miss Charlita Burton, that is CHARLITA Bunton, BUNTON. Although the defendant does not have any arrests, this is not his first run-in with Miss Bunton. On several occasions, the defendant has been asked by Miss Bunton to not contact her anymore. She has also filed 3 police reports against the defendant in this case. The defendant has a history of calling for welfare checks on Miss Bunton, and after those welfare checks are completed, he will show up at her residence despite the request for him not to contact her. On this specific incident date of August 25th, 2022, a welfare check was again requested for Miss Bunton at the address of 570 Greyhound Court. Ms. Bunton informed officers when they arrived of the situation between herself and the defendant. And Ms. Bunton also advised the officers that she is in the process of getting a temporary protective order against the defendant. While there is no history, as I said, no arrest history, there is significant history with this victim, and we do sense a risk of intimidation and risk of reoffense, seeing as he continues to harass and stalk Ms. Bunton despite her request and her police reports. As such, we are asking for a $3,000 surety bond, a stay away order from 570 Greyhound Court, and no further contact with Ms. Charlita Bunton, as well as no drugs, alcohol, and weapons.
All right, thank you. I'm gonna sound for Ms. Bunton first. Is Ms. Bunton on this Zoom conference and wishes to make a statement? All right, hearing none. Please proceed, Ms. Kim.
Yes, Your Honor. Mr. Hampton is 22 years a young man. He has been here in Georgia ever since he was 6 years old. So he went to elementary, middle school, high school, all here. And indeed, the complaining witness and my client went to high school together for 4 years, and they were dating on and off. And all of a sudden, he could not contact her. There was no context. So he just wanted to see what was going on. Indeed, my client did not even have a chance to talk to her. It was her stepfather who came out and told him that, he cannot talk to her. Ever since then, August 25, 2022, he has not gone there at all. And there has not been any other incident. I don't think he was actually stalking at all. He was not harassing anybody. He was not bothering anybody. He just wanted to find out what was going on with her. And as soon as he was told that by his stepfather, he does not go there anymore. Your Honor, he's a young man who is actively looking for a job. His grade was A's and B's, and he dreams to enroll to Georgia Tech very, very soon so that he can go and pursue his career and education. He needs to be getting signature on bond. This is his first offense ever, and which I really think he is falsely accused of. We would like to request for a signature on bond for him. Thank you.
Your
All
Honor,
right.
if I may.
Very quickly.
Very quickly, I do just want to point out the fact that this is not the first instance where he has not been able to contact Ms. Button. She has 3 police reports dating back to 2021 concerning this same incident. So this is not an isolated incident. And there, as Ms. Button told the police, there have been 5 times where he has called the police for a welfare check and arrived at the scene after the welfare check was completed and been told to stay away from her.
All right. At this time, the defendant will receive a $1,500 surety bond. He's to have no contact with the alleged victim, last name Bunton. Ms. Todd, will you please give us that incident location he needs to stay away from?
Yes, Your Honor, it is 570 Greyhound Court.
He needs to stay away from that location and have no alcohol, drugs, or weapons as a condition. Is there anything further? All right, best of luck to you, sir. We can go to the next position.
Position 7, Mr. Cox.
All right, good afternoon, Mr. Cox. Your case number 22 CR 007931Y. In this case, you're charged with theft by taking with the offense date of November the 22nd. Do you understand your rights?
Ma'am, you understand your rights.
You understand your rights? You have a right.
Misunderstand, just now take me to just misunderstand, that's all. But I'm okay.
All right, but you understand you have a right to remain silent. You have a right to an attorney today?
Yes, ma'am.
All right, perfect. That's what I need to know. Mr. Howard?
31 total, last was 2017, interference with government property dismissed. Failure to appear conviction from 2017, probation 2017. Shoplifting conviction 2017, shoplifting arrest. 2017, another probation violation. 2016, shoplifting conviction. 2015, trespass, trespass conviction. You want me to keep going?
No, that's good. Thank you. Ms. Campbell, please proceed.
Yes, Your Honor. And there's additional theft by shoplifting, theft by receiving, and theft by taking convictions for that defendant. I won't get into the dates, but I didn't want to add that. So the defendant is alleged to have stole $5 from a tip jar without consent of the owner of the establishment, and that establishment is called Dancing Goats. The location is 650 North Avenue, and this happened on yesterday, allegedly. So the state, based on that history, does believe he's a risk of reoffending. It's the same types of crimes that he has convictions and arrests for previously that he's alleged to have committed on yesterday. So the state's recommendation is a $1,500 surety bond, as well as a stay away from the incident location.
All right, thank you, Ms. Gant.
Thank you, Your Honor. Mr. Terry Cox is 45 years old. He has been in the Atlanta, Georgia area for 4 years. He has 2 children, ages 18 and 20. He does not have any family here in Atlanta who's willing to assist with bond. Mr. Cox completed the 11th grade and he is, Your Honor, disabled and has been so for 4 years. These are allegations. He denies the allegations. He's presumed innocent. I am requesting a signature bond for Mr. Cox. I believe the last arrest that I heard about was in 2017. And of course, theft was in 2016. We believe that those are remote convictions. And he doesn't have the means to bond out, Your Honor. So I'm asking for a signature bond on Mr. Cox's behalf. And we are unopposed to the stay away, Your Honor. Thank you.
All right, thank you. At this time, the defendant will receive a $5,000 signature bond through the jail. He's to absolutely stay away from that location, I believe the Dancing Goats, and have no alcohol, drugs, or weapons. Is there anything further?
Nothing,
Your
further,
Honor.
Your Honor. Thank you.
All right, best of luck to Mr. Cox. Do not go back there. All right, who do we have next?
Position 11, Mr. Nico.
Go back to the week now.
Yeah. We good.
Now, right there.
Hey. Second row.
Nah, he going back there.
Okay.
All right, good afternoon. Your case number 22 CR 007942E. In this case, you're charged with improper passing, driving while your license was suspended, no insurance, knowingly driving on a suspended, canceled, or revoked registration, expired license plate or no license plate, willful obstruction, and theft of service, quite a few things, with the offense date of November the 6th. Do you understand your rights? All right.
Yes.
All right, Mr. Howard.
Judge, what's the name of the defendant, please?
Position 11, I think it's Meikle. I'm not sure I'm saying that correctly.
Ninth arrest. Last arrest was 2021, suspended license. Use of a firearm by a convicted felon during the commission of a crime. It's 21 CP 197271. History out of New York, Pennsylvania, California, and Florida. California got a 2018 obtained credit ID. That was a conviction. 2017 out of Pennsylvania for theft by deception, theft by unlawful taking. Those were dismissed. 2014 out of New York, criminal possession of stolen property, 4th degree, larceny, 4th degree, motor vehicle, use of a vehicle, disorderly conduct. So he was convicted for the disorderly conduct. What else we got here?
I think that's good. I'm sure Ms. Todd
You
will
sure?
fill us in. I'm sure Ms. Todd will enlighten us as well. Ms. Todd, please proceed.
Thank you, Your Honor. On the incident date of November 6, 2022, Georgia State Patrol Officer Byrd was conducting a traffic stop when the defendant's blue BMW passed the officer without changing lanes or slowing down his speed. While the officer's emergency equipment was activated, Officer Byrd was able to pursue the defendant and complete a stop of the defendant's car. As the officer was attempting to conduct the stop, he noticed that the defendant refused to take his foot off the brake. So therefore, the officer asked him to exit the vehicle. When asked for his driver's license, the defendant stated that he didn't have it on his person and that he would have to go to New York to fix that. Officer Byrd was able to identify the defendant using his fingerprints. When he ran his fingerprints, the GCIC did return that he had a suspended license. His registration was suspended. He did not have insurance, and the vehicle's tag was expired. When asked about the insurance, the defendant did give 2 conflicting stories as to why he didn't have insurance. The defendant's vehicle was subsequently towed by Futo's wrecker. And when the defendant did go to retrieve his car, he left the scene without paying for the wrecker services. As pretrial stated, he does have somewhat of a history here, Your Honor. His driver's history shows that there are 7 suspensions of his license, and he has 2 arrests for driving while his license was suspended. And as such, with all of these charges, we are asking for $1,000 surety bond on each, which would make a total of a $7,000 surety bond. We also ask for the conditions of no driving, as well as no drugs, alcohol, or weapons.
All right. Give me one moment before we go. Is this Miss Kim? Give me one moment, Miss Kim.
No problem, Your Honor.
All right, Miss Kim, go ahead, please proceed.
Yes, Mr. Dumont is actually, he's been here for about 2 years, Your Honor. He has 2 children who are under 2 years old, and he has aunties and uncles here at Georgia. He's also self-employed as a barber for the last 3 years. He graduated from high school. He does need to have a car to, I would like to ask for driving only for a limited purpose if he has a valid license, for courts and medical reasons, and of course, work and meeting an attorney, Your Honor. We would like to request for signature on bond, because these are all traffic issues. And however, if Your Honor is not inclined to give him a signature on bond, we would like to request for maximum $2,000 total good bond. Thank you.
All right. Give me one moment. I am terrible at math. All right, the defendant is going to receive a $1,750 surety bond. That's going to be $250 of surety on each count. He is not to drive unless he has a valid license, insurance, and registration, and he is to have no alcohol, drugs, or weapons. Is there anything
Thank you.
further?
Nothing further, Your Honor.
All right, best of luck to you, sir. Who do we have next?
Position 12, Mr. Smith.
All right, Mr. Smith, good afternoon. Your case number is 22 CR 007939F. In that case, you're charged with simple assault with the offense date of June the 26th. Do you understand your rights?
Yes.
All right, Mr. Hart, can I have his history, please?
This is third arrest. Last was in July for simple battery and obstruction. That's open. 22 CP 107746. On probation for disorderly conduct. 22 SC 181448. I'm not
All right.
sure. Hold on, Judge. Let me see something real quick. Is he on probation? Oh, it was a criminal damage to property reduced to disorder. Okay. I was wondering why I was a SC with that case, but that's
Okay.
it. All right.
Thank you. Ms. Todd?
Thank you, Your Honor. On the incident date, Your Honor, the defendant did go to the victim's door, Miss Rashida Castro, that is RASHEEDAH. Castro is standard spelling. And it was seen on Miss Castro's security footage that the defendant was threatening violence against her. This is not the first incident between the defendant and Miss Castro. The defendant is to our knowledge, boyfriend of the resident above Miss Castro, and Miss Castro has made 8 different complaints to the police regarding noise coming from the defendant and his boyfriend's apartment. And on this incident date, after making a noise complaint, the incident did escalate to the point where the defendant came to the door, was using expletives, threatening violence, threatening to smack I'll leave that word out of her, and that he would also F her up. So we do believe that there is potential for violence with that open simple battery case. We do fear that there is a potential for things to escalate, especially because we are still under the knowledge that his boyfriend does live at the address near Miss Castro, which is 260 Elm Street. With that open simple battery, we do sense that there is a risk of reoffense here, seeing as he was on bond and has committed now 2 crimes since then. We also do, so for these reasons, Your Honor, we ask for a $3,000 surety. We ask for a stay away from 260 Elm Street, and we ask for a no further contact from Miss Castro, as well as 1 day of anger awareness and no drugs, alcohol, or weapons.
All right, I'm going to sound for Ms. Castro at this time. If she's present on this Zoom conference and wishes to make a statement. All right, hearing none. Ms. Kim?
Yes, Your Honor. Mr. Smith is 27 years old, Your Honor. He's been here in Georgia for about 2 years, and he doesn't have any children. He's not married. He works at UPS part-time. He's been working there for about 1 month, and he really want to keep his job. He does not want to miss the work anymore. Your Honor, there is a $3,000 current bond. However, we would like to request that it will become either signature on bond or maximum $1,000, because apparently they moved out from that apartment. There was too much conflict with complaining witness, who really has to address the issues to the landlord instead of my client, because it is not my client who's making more than normal noise. It's just that apartment has a really thin wall. There's no soundproof. Things has to be dealt with landlord. However, my client and his roommate, they moved out of that apartment place. They are no longer there, so there's no reason to get together at all. This happened on June 26, 2022, Your Honor, almost 5 months ago, and they moved on. They don't have to see her again. No further contact. Stay away. Completely fine. And she indeed had a gun against her. Unfortunately, it's not in that security footage, but anybody would be very afraid when somebody has a gun against you. Anyway, we would like to request for signature on bond for this case, maximum 1,000 if Your Honor is not inclined to give him a signature on bond. He has been in jail ever since, from September 2nd, 2022. Fulton
All
County.
right.
Oh,
All right.
yeah. Thank you.
All right. Anything further, Ms. Kim? I mean, to cut you
2.5
off.
months he was incarcerated for all those charges anyway, Your Honor. Thanks.
All right. At this time, the defendant will receive $1,000 surety bond. He is stay away from the incident location and have no contact with Ms. Castro, have no alcohol, drugs, or weapons. Is there anything further?
Nothing further, Your Honor.
No, Your Honor.
All right. All right. Best of luck to you, Mr. Smith. Who do we have next? Everything all right at courtroom 2? All right.
Yes, ma'am.
Okay.
Can we go back to position 10? I'm sorry. This is 13, position 13.
All right, position 13. All right, good afternoon. Your case number is 22 CR 007940B. In this case, you're charged with criminal trespass and possession and use of drug-related objects with the offense date of the 22nd of November. You understand your rights today?
Yes, ma'am.
All right, Mr. Howard.
His 8th arrest, last was back in August. Possession of drug-related objects. Got a trespass as well, on probation for ag battery. 2019, they gave him 15 years probation. 19 SC 168058. 2018, arrest for reckless conduct. 2018 battery DV, criminal trespass. Trespass was a conviction. I don't see the disposition for the battery. And before that was 2009 disorderly conduct.
All right, thank you. Ms. Todd?
Thank you, Your Honor. On the 22nd of this month, Your Honor, as MARTA Officer Blaylock was doing a patrol around the Garnett MARTA station, he observed the defendant sitting on the wall of the alley, which is an area that is off limits to non-MARTA personnel. When the officer did approach him, he was able to notice a glass pipe a pill bottle sticking out of the defendant's pocket. When asked if he maintained anything else, a glass pipe was found in his pocket as well. Officer Blaylock did do a check for suspensions from MARTA, and it was found that the defendant does have an active suspension from MARTA, which is why he was arrested and criminally trespassed from the property. We do have, as pretrial stated, he does have that open possession of drug-related objects case. He is on bond for that case as well, with a condition of no drugs, alcohol, or weapons. It was a signature bond, and he has clearly violated that bond, as well as the probation for his aggravated assault. We do ask for a $2,000 surety bond on count 1 for the criminal trespass, as well as a stay away from the Marta Garnett station. And for the possession of drug-related objects, we do ask for a $1,000 surety bond, as well as alcohol and drug treatment, and no drugs, alcohol, or weapons, for a total of a $3,000 surety bond total.
Was there any drugs alleged to have found on him, or just the pipe itself, Ms. Ty?
The only mention of drugs was the pill bottle. It does not mention whether
Pill
anything
bottle.
was found in there.
All right, thank you. All right, Ms. Kim?
Yes, Your Honor. My client says that he has a prescription medicine that he has to take, even though there was no drug, alcohol, and weapon allowed in the bond condition. Always there's exception for prescription drugs that he has to take for his medical conditions, Your Honor. He has been here in Georgia ever since. He's been here for almost 17 years, Your Honor. He is 42 years old, and no, 44 years old. And he has 5 children, and he has to take care of all of them. And one of them actually has a mental health disease that he really needs a lot of attention from the parent. And he's been gainfully employed at CVS for last 12 months, and he cannot lose his job because he's got to take care of 5 young children. He graduated from high school, and he also has a little bit of trade school experience in engineering, Your Honor. We would like to request for signature on bond for this case, and if not, maximum $1,000. Thank you.
All right, at this time, the defendant is going to receive a $2,000 split bond. It'll be 1,000 surety on the criminal trespass and 1,000 signature through the jail for the possession. He is to stay away from the Garnett station and have no alcohol, drugs, or weapons without a prescription. Is there anything further?
Nothing further, Your Honor.
No, Your
All
Honor.
right, best of luck to you, sir.
May I ask, it was the signature bond, ma'am?
Signature bond means, please speak to your attorney. I don't want to speak to you directly, but essentially I'm allowing you to sign part of your own bond, and you will not have to pay the bond out on that part, okay?
Thank you, ma'am. I appreciate that very much.
All right, your attorney will explain further. Best of luck to you, all right? If I could be placed now into the breakout with Ms. Kim, I believe Ms. Gant asked for a breakout as well, ASG Campbell. And I'm sorry, who else would need to be into the breakouts?
And Your Honor, I'm objecting to the breakout. Can the state put its objection on the record?
Sure, duly noted. We'll be going in there. All right, let's go into our breakout.
I'm sorry, before you get that, can I have the bond amount on both charges?
1,000 surety for the criminal trespass and 1,000 signature through the jail for the possession.
All right, thank you.
You're welcome.
Your Honor, may I be placed in the breakout room as well?
You may.
Thank you.
Everyone's free to join the party, except the public. All right, we are returning to the main session. Who do we have before?
Position 10.
All right.
Harmon.
All right, as this is Ms. Harmon's first arrest, I've heard arguments from both the state and the defense as it pertains to this case. The defendant in case 22 CR 007937G. I will not sound this charge at this time with the offense date of October the 6th. Do you understand your rights today, Ms. Harmon? All right, at this time, the defendant will receive an $8,000 signature bond through pretrial services. She's to complete a one-day anger awareness course, have absolutely no contact with the alleged victim, last name Head, at this time, and stay away from the address on Utah Circle. And I believe that will conclude Ms. Harmon's case. Is there anything further from the state or the defense at this time?
Nothing further, Your Honor, from defense. Oh, Miss Harmon, you have signature on bond, which is the best thing you can get. Please give me a call. I'll explain to you. Please stay silent. I strongly recommend you to stay silent. You don't want to talk about the facts of the case at all.
All right, yes, please go talk to Ms. Kim.
Yes, I'll call you.
All right, best of luck to you, ma'am. All right, who do we have next? Position 1?
Yes, ma'am.
All right, Mr. Howard, would you please give us the history for the record? Position 1, case 22 CR 0079. Oh, please excuse that message that I sent. I apologize. 22 CR 007934G. And the defendant is charged in this case with a charge I will not sound, with the offense date of July the 1st of 2022. There, give me the history.
He got 11 total. Last was back in July for PI. Let's see. Before that was 2020, failure to appear for obstruction, PI, trespass. That came off a 2020 arrest. I got a 2019 trespass conviction, ag battery against law enforcement conviction, 2017 criminal damage to property, second degree conviction. And before that was 08 probation.
All right, thank you. Having heard the arguments from both state and defense, I will leave the bond currently as set at the $10,000 surety bond. Defendant must stay away from the incident location. I'm sorry, Ms. Campbell, can you give me the address again? I have it as a Union City Walmart, but I do not have the number.
It's 4735 State Route 138.
All right. He must stay away from that location and have no alcohol, drugs, or weapons as a condition. Is there anything further from the state or the defense as it pertains to that defendant?
No, Your Honor, thank you.
Nothing from the defense. Thank you, Your Honor.
All right, I believe that concludes the entire calendar with the exception of the waive case, position 8. Courtroom 2 can be excused at this time.
I'm sorry, Judge. On the position 10, was that through the jail, the signature bond?
No, it's through pretrial.
Pretrial? Okay, thank you.
Thank you. All right.
For Binion?
No.
Position,
oh, the other
position 10, please. Throw me off. Candace Harmon. All right. If we could do the waive derangement case 22 CR 007916D, in which the defendant is charged with hit and run and duty to stop or return to the accident scene. Can I please have that history, Mr. Howard?
Robin Evely, last arrest was November 14th for simple battery. 2 counts of possession of a firearm by convicted felon or felony first offender. Reckless conduct, giving false name. That's out of Cobb. Probation violation from 2017, 18, 19, 2020. She went to felony, or he went to felony yesterday or day before and got a $10,000 good bond.
Okay. Okay. All right, Ms. Todd.
Thank you, Your Honor. On November 23rd of last year, the defendant was driving a white Chevy Malibu on Alpharetta Highway when his vehicle collided with the vehicle of Claudia Gonzalez. That's Claudia. Gonzalez is common spelling. Both the defendant and Ms. Gonzalez did pull over to the side to a safe area. And the defendant told Ms. Gonzalez that he was going to leave the scene to get the owner of the vehicle and return to the scene. However, a few minutes later, only the owner of the vehicle and Miss Abria Barkis, that's A''B-R-I-A Barkis, B-A-R-C-U-S, returned. She was able to speak with the officer, Daniel Tyler, and the officer did tell her that she needed to have the defendant return to the scene. However, he stated that he would not be able to return to the scene because he was at work. Officer did allow for the defendant to stay at work and told him that he needed to contact him at a later time to give his statement. However, the defendant never made contact with the officer, as well as he ignored the officer's attempts to contact him. For this defendant, there is an open battery case out of Fulton County, 22 CP 214145. He also does have an outstanding warrant in Clarksville for violating a court order, as well as an outstanding warrant in Milton, Georgia for simple assault. As pre-trial stated, he has 8 probation violations, so it is clear that he does not like to comply with the orders of the court. For this case, Your Honor, we are asking for a $5,000 surety bond to remain in place as it has already been set. We ask that there be no driving, as well as no contact with the victim in this case, Ms. Claudia Gonzalez, as well as no drugs, alcohol, or weapons.
All right, Ms. Kim.
Yes, Your Honor. Mr. Avley is, he was born in 1997. He has been here in Georgia for about 13 years, Your Honor. He has 3-month-old newborn baby with Miss Abria, who is the owner of that car. Your Honor, he gave his driver's license, a copy of the driver's license. He gave all the information to Gonzalez. Not only that, the owner came right away to take care of the matter, and he did not want to lose his job because he is the sole breadwinner for his newborn baby, Your Honor, and fiance right now. We would like to request for signature on bond. He's not going anywhere with a $10,000 good bond in another charge, and he also has to take care of other issues. For this matter, though, he did not run away. He moved from 1396 to new address. Maybe because of that, there was some kind of change of address and change of phone number. He did not mean to ignore the police. It's misunderstanding, Your Honor. The owner and driver were both responsible for all these accidents, Your Honor. We would like to request for signature on bond. Thanks.
All right, at this time, the defendant will receive a $3,000 surety bond. He's not to drive at this time as a condition of this bond. And he is to have no alcohol, drugs, or weapons. Is there anything further from either party?
Nothing from the state, Your Honor.
Your Honor, actually, can he then get a limited driving privilege to go to work and to go to courts, medical reasons?
What was his, I'm sorry, I did to make us go back to this. Mr. Howard, very, very briefly, can you give me the quick, or Ms. Todd, if you have it, the driving history?
Oh, I don't have the driving history, Judge.
Ms. Todd, do you have the driving history?
Let me see if I can pull it up really quickly, Your Honor, if you'll indulge me.
Okay, because I'm inclined to allow it if he does not have a very serious driving history, but I do agree that there was a serious driving offense committed here. If his driving history is tainted significantly, Ms. Kim, I'm gonna stick with the original ruling.
Let's see, Your Honor, he does have driving under the influence, speeding, a seatbelt violation, a commercial DUI, another DUI, as well as an old school suspension.
Okay, Ms. Kim, the original ruling will stand. All right, is there anything further?
Nothing further, Your Honor.
No.
All right, best of luck to that defendant. Ms. Bridgewater, will you please review the calendar for me?
Yes, I will. Once again, the reset date for the SAP calendar is going to be December the 6th. Position number 1 is going to the SAP calendar with a $10,000 good bond. Position 2 is going to the SAP calendar with a $2,000 total good bond. Position 3, SAP calendar with a $3,000 cash only bond. Position 4, SAP calendar with a $3,500 good bond. Position 5, SAP calendar with a $2,000 good bond. Position 6, SAP calendar, $1,000 good bond. Position 7 is reset further notice with a $5,000 SOB through the jail. Position 8, SAP calendar, $3,000 good bond. Position 9, SAP calendar with a $1,500 good bond. Position 10, reset further notice with a $8,000 SOB through pretrial. Position 11, reset to the SAP calendar with a $1,750 good bond. Position 12, SAP calendar, $1,000 good bond. And position 13, going to the SAP calendar with a $2,000 total split bond. Are there any questions, comments, or corrections?
What was number 9 again?
Number 9 is reset to the SAP calendar with a $1,500 good bond.
Thank you.
Okay. And on that, everybody have an awesome Thanksgiving.
Happy Thanksgiving to you all.
Take care,
Yeah.
everyone. Enjoy
Thanksgiving.
hearing that there's nothing further. See everyone tomorrow at the, not tomorrow, but
Oh,
Friday.
no, please
Not
no.
tomorrow. Not tomorrow. See everyone on Friday. Take care.